morning. I'm going to call for argument our first case on docket this morning, William Travis Kitchens versus State of Texas, number 054124. We will hear first for the appellant. And I will ask if you could please state your name when you get to the podium so we can keep track of you. And I understand you're dividing 10 and 10. Counsel, I'm going to ask when you start if you wouldn't mind giving us a little bit of the factual background of this case for the benefit of those of us in the room who aren't as familiar as we might be with it.
I had planned on that. Thank you for the opportunity. First, all the mics on. Unusual courtrooms, I can't hear. What I first wanted to talk about was what I would refer to as the reason for this trial.
Let me ask first, can you move the microphone up a little bit so that people can hear you?
Better?
Thank you.
Yes. Thank you. The case was first tried on a normal basis. The defendant was convicted of murder and an appeal was processed. And I believe 2020, the first Court of Appeals reversed on punishment only. So the reason for the second trial was based on the failure to give an instruction to the jury on sudden passion in the first trial. So basically all we had was the punishment phase is a second trial. If you have specific questions, I'll try and answer them.
Well, if the background of the facts in terms of the event, if I'm recalling correctly, this was an event that transpired in an auto repair business that turned violent. Is that right?
Yes, and that's a good way to start because, first of all, this is not your run-of-the-mill auto repair shop where you might go and get your oil changed on your Range Rover, whatever. This is a high-end shop. They don't do basic repairs. Custom cars, Ferraris, Maseratis, things like that. And that is part of the mix of the story. Part of the state's case to begin with was the defendant's attitude from the beginning when the deceased first arrived at the premise riding back and forth on a motorcycle, a loud motorcycle. Testimony from both the firm appellant and co-workers was that this was not someone they would normally see in their business, and I guess the best way to say it troubled them, right? I think there is little dispute about the facts of what occurred, which was the deceased showed up looking for an individual, clearly not looking for work at this shop. And in the manner in which he identified this individual for who he was searching, appellant could not recognize this as any current or former employee and tried to tell him, I don't know this. I don't know who this is. And apparently, the more appellant would say, I don't know who that is, the angrier the deceased would get. And trying to limit it to just those things that are not in dispute, it's clear that the two were arguing loudly, and then the deceased closed the door to appellant's office. And mind you, this is a small office, chair here, door there, door there. And so you have a situation where, although there's no duty to retreat anymore here, there is no retreat because the only way out are blocked by this large, angry person in front of the appellant. And at that point, he shot the deceased, who died, and we're here on the murder case. It seems to me that it is important to understand the reasons for the trial because you have to ask yourself, what is it the state could accomplish in this? If they got 18 years sentence after the first trial. If the jury were to agree on the sudden passion, that would limit this to 20. And it appears to me that The state's sole job here was to find a way to make sure that they didn't bite to sudden passion and got a bigger sentence than they got.
Counsel, could you articulate to me what the sudden passion argument that the defense was offering was? What is the theory for sudden passion in this case?
What is the period?
Theory. What was the defense strategy on that?
The situation. It's the basic argument, and which was presented in the first trial, but the judge declined to give a sudden passion thing, is that the situation gives rise to this. Besides the idea that there is an intermingling sometimes between self-defense and sudden passion, what you have is a situation with a very large, angry individual and a smaller individual who's armed, and there is threatening behavior, testimony about threatening words, although the only one who said that was Appellant. But the situation, this would normally rise your passions when some large person, much larger than you, is threatening you and blocking your way out.
That does what to mitigate? How does that mitigate punishment in this way? If there's a large person threatening you, why does it mitigate punishment? What is the theory behind which this would mitigate punishment?
Well, I would disagree with the use of the word mitigating, because sudden
Lowering?
passion is murder, but under these circumstances.
Sure.
And it's like, if the jury were to believe the circumstances that the deceased behavior caused the defendant to act in the way he did because of this behavior, that would be sudden passion, right?
So the defendant would not be capable of cool reflection.
Yes.
Right.
Now, first thing I would say is, the first word I'd like to push is disingenuousness. At the trial, prosecutor said, when there's an objection to the comment about race, prosecutor says, I'm not talking about the defendant's race, I'm talking about the deceased race, which is the same thing.
That's the issue that we're here to talk about, right?
Yes.
Is the use by the state of a sort of a racial argument in the course of closing arguments in the case, right?
Yes.
Yeah.
Closing arguments, but only with respect to the punishment phase.
That's all we're there for.
Right.
Counsel, is it Appellant's position that race played no role in this confrontation?
Absolutely.
It is your position race had no role?
None at all.
Then if that's the position, why the repeated references to Hispanolito, or the Christian name, and the bandito, and those references?
Well, first of all, that's one thing I'd like to point out. The word bandito appears once in the record in a sentence where Mr. Schneider was about motorcycles and banditos. Now, admittedly, the court reporter took it down as banditos rather than banditos, but that is part of why I say this argument from the beginning was disingenuous, because I find it unfathomable that a lawyer at this point in time would not know that motorcycles and banditos means the bandito motorcycle gang. So I can't say.
Did bandito go before the jury? Did the reference to banditos go before the jury?
In voir dire.
In voir dire.
Oh, let's say there was only one reference to the word.
Evidence in the trial that the jury could have considered.
About him being in the bandito?
Yes.
No, because the state introduced a photo of the deceased motorcycle, but was able to exclude a close-up with the sticker that had was BYSB, support your local bandito. So that's the point is, the only word Hispanic only appeared in the autopsy, and the word bandito was only mentioned once in voir dire.
Who mentioned it?
With motorcycle.
Counsel, who?
Defense.
Defense counsel used the word bandito.
Excuse me if I don't quote it perfectly, but the question was, if I say motorcycles and banditos, what does that make you think about?
And that was defense counsel.
That was a question in voir dire.
So are we focused on irregularities in voir dire? Or are we focused on proper jury argument?
Proper jury argument,
Right.
And the use of race. The other thing I would say is this. For the very reason that the voir dire was about motorcycles and banditos, any criminal lawyer should know about the banditos. That's one thing, but then the other is in the brief, in the record, and the use of the word bandito, and go on about that, mentioning it 7 times in their brief, including a reference to Webster's dictionary on that word, when there is absolutely no way that they could have believed that was what the defense was talking about.
I'm sorry, you indicated that the state altered or edited a photo to eliminate a sticker that said what?
No, the photo was introduced by the state.
And
But
it
what
said-
they objected to, the defense wanted to blow the photo up so that the jury could see the sticker on the back of the motorcycle referring to the
The
Banditos.
motorcycle ridden by
The
victim.
deceased.
And it said, support your local banditos?
It said,
Did it say that or just have an
SYDL.
acronym?
In essence, they kept out information about the deceased being in the Banditos.
It was the defense attempting to obtain that information for the benefit of the jury, right? That the defense wanted the jury to know.
I think they more wanted to know what the jury thought about the Bandito motorcycle gang. Let me just say this, so I'm out of time, but I'll
Take another minute.
Okay. The situation. You cannot ignore the situation in the context. A situation where a small man is being threatened by a very large man, I can assure you there was nothing in his mind other than alleviating this danger. Not what race is he or anything like that. That I can assure you. This was not about race. This was about danger.
Well, counsel, one final question before you go then. The last shot was when the victim was laying on the ground, previously shot. He was
Yes.
shot through the eye. At what level of danger did he represent to the appellant while he was on the ground shot?
That's a difficult question, obviously.
I agree.
What I would say is, at that point, the skunk was already available to put in the jury box. And when the state argued that this was about race, that question becomes unnecessary because it's a guilt-innocence question, basically. We're only talking about what's in the defendant's mind, and the fact that he would get up, walk around, and put another bullet into him has nothing to do with guilt-innocence. He'd already been found guilty in the first trial. This is, was he acting under sudden passion? And to be candid, while I can't justify that, I would say, having been in these situations, that's all part of the mix. One of the things you're not doing when you're acting under sudden passion is thinking logically. You're so worried about this. What I have to do is stop this danger and make sure it doesn't come back.
So, I'm sorry, I know that you're out of
That's
time
okay.
here and I'm adding on to this, but so if you're not thinking logically in sudden passion, for your basis of your sudden passion argument, are you saying that the defense should be allowed to introduce the idea that the victim is Hispanic as part of showing why the defendant is incapable of cool reflection?
Absolutely not.
Okay.
And there was no attempt by the defense to put in anything about the race of the deceased. His name is Hippolito. It's in the indictment and it's in the charge, right?
Okay.
Referring to the deceased by name is not improper.
So if that's not the argument by the defense, what does that do to the state's argument that this is a rebuttal by introducing his?
You have to ask yourself, what are they trying to rebut?
Yeah.
Okay, they say they're rebutting this outlaw biker who appears once. But neither bandito, outlaw biker, or biker translate into Mexican. The defense made no reference whatsoever during voir dire or the trial to the deceased's race. That was what the state injected.
I have a question.
Yes, ma'am.
We know that you cannot make an issue out of the race of the defendant, but what Texas Court of Criminal Appeals case or law do you rely on saying that the state cannot raise the issue of the deceased race?
Your Honor, I would say the race of the individuals has no place in a trial. Our brief cites the supplement that Mr. Schneider filed yesterday morning have several cases, and the Supremes in both Texas and the United States have basically said that. Race has no part in the trial,
Correct. And,
right, either side.
and what about, is there any case law for our court from the Texas Court of Criminal Appeals on this issue?
Not yet. Thank you, Your Honors.
Thank you.
Now hear from your co-counsel.
I think that
May it please the court, my name is Chris Conrad. I represent the state of Texas out of Harris County. The issue today, the fundamental issue underlying this case, discretion when it overruled the defense's objection to the state's closing argument, claiming that the state injected race into this case. And I'm going to go through why, but the short answer is that was not error, and the reason is because that race had already been injected into this case by defense counsel. And for that reason, it was a response to arguments, and it was also a reasonable deduction based on the evidence, including the defendant's testimony and the video evidence of the entire murder scene, which only took 2 minutes and 5
Counsel,
seconds.
could you explain to me how how the arguments of the state were a reasonable deduction from the evidence?
Yes, Your Honor. Reasonable deduction, so skipping down, when the defendant testified, he testified that he experienced terror because of Mr. DeSoto's appearance and his words. And there's case law saying words, even words and pushing, are not enough to get to sudden passion. But they're trying to allege sudden passion, and you have a video where the complaining witness is standing with his hands at his side, unarmed. All there are words, and only words for about 8 seconds from the time that he doesn't close the door, he opens it slightly and turns around.
I mean, that's a good argument. I hear that. I'm just not hearing where the state's argument sounds then to be the evidence doesn't really raise sudden passion, not, oh, we need to make the argument that the victim being Hispanic negates.
Sure. Sorry, I was getting there,
Okay.
but I'll get there more directly. So basically, I would argue it was introduced in voir dire with the term bandito, which I cite is Mexican outlaw. That's a direct reference to the complainant's race.
But is that evidence? Is bandito evidence?
There's no evidence that the complainant was in the banditos, that he was even associated with, or that even that SYLB stands for Support Your Local
Does it need to be
Banditos.
evidence before the trial judge could act within his discretion to allow the state to respond? I mean, the argument here, if I understand it correctly, coming from the appellant, is not about evidence that came in at trial. It's about argument and closing, correct?
In closing, the defense counsel went outside the record by calling the complaining witness an outlaw biker. So that ties back to voir dire when he referenced banditos. There's no one single point. You have to look at the entire...
You would concede, I assume, at some point that we generally don't want lawyers for either the defendant or the state injecting the race of the defendant or the decedent into the proceedings for the jury to contemplate as they make whatever judgments they're making with respect to guilt or innocence or punishment, right?
Yes, if it had not already been admitted, it would be entirely inappropriate for the
Here's the
state.
big questions I see for you. At what level of use of race by the defense would allow the state, or more importantly, the trial judge within his discretion to allow the state to essentially call it out for what it is? The defendant is trying to say he was acting properly and shooting this person because he was big, scary, and Hispanic.
Right, and that is the underlying question in this case, and there's no bright line rule, but what I can say is if you look at the context, and I can go through all of the factors, this case is far beyond that line. And one way you can tell is if you reverse this, and if the state had done this, and if the state had argued about the defendant, or asked about the defendant being part of banditos and motorcycles, and then called him an outlaw, bandit in closing, and had done the other things I'm going to discuss, that would have been reversible error. And so that shows you, I think at that point, it's beyond the line. Race was injected by the defense attorney. Yes.
Yeah, I want to get back though to my point because the areas of permissible jury argument include reasonable deductions from the evidence, which is what you said.
Yes.
But there isn't any evidence of the bandito or any of that which you acknowledged. But you did say that the defense went outside the bounds of the record in argument, which would really just make this a rebuttal or response type of situation. So that's really the argument that we have before us then, is that this is a response to defense's argument, not necessarily a reasonable deduction from the evidence.
I would say they're mixed. I think probably the stronger argument is that it's a response to argument by defense counsel. And I will say why I think that it is also a reasonable deduction, and that's because the defendant testified, and he said words and the complainant's appearance caused him terror. And I can go through, and you can go through and all the things that he said
So
were scary.
appearance injects race?
Yes. In this case, because the appearance is on the video, and you can go through every reason, every factor about the appearance of the complaining witness they discuss could have been rationally rejected by the jury. That includes the fact that he was on a motorcycle, where there's testimony defendant rode motorcycles, defendant's friend worked on motorcycles. There was someone in the area that rode a Harley by to work, so that should not have scared them. His clothing, he was dressed exactly, almost exactly the same as the defendant. He was wearing tennis shoes, shorts, a dark solid shirt, nothing related to a gang, nothing even related to a motorcycle club, except for the fact that he was on a motorcycle. And in the evidence, you learn he actually worked as a high-end motorcycle mechanic on Harley Davidsons. He was there for work, looking for someone, for a pipe fitter. He had the pipe in his pocket. He was there trying to find a mechanic. So he was there for work reasons. It wasn't his sunglasses. He flips his sunglasses up when he comes into the store. When he falls down and dies, they come back down on his head. So there's a picture of him wearing the sunglasses. But those glasses were up if you watch the video. His height, he was only 1 inch taller than the defendant. His beard, the defendant had a beard. His weight, that's the one factor. He was about 100 pounds heavier than the defendant. He was obese, but the defendant had a loaded firearm, had a desk between him, and had 2 able-bodied 20-something males, his friends, in the room right next door. So I would say the jury could easily reject that as a reason for his appearance causing this terror. It's not weapons, because the complainant didn't have weapons. It's not drugs, he wasn't on drugs. It's not the time of day, it was open to business, and it's not his confusion, and that is actually a key point, and that's one of the reasons. Basically, process of elimination, you eliminate every reason from his appearance. What are you left with?
Right.
What's the logical deduction?
There's no sudden passion. You make a great case for why there's no sudden passion, but I'm still not hearing where the race of the defendant mitigates, or it was either used to support sudden passion or not.
The way you do that is
Or the
because
victim.
the defendant testified, I was scared because of his appearance. I was terrified.
But if
The jury could reasonably, sorry.
I'm
Judge.
sorry. I'm curious. I'm trying to play this in different directions, right?
Yes, Judge.
If the victim had been a white bald guy with a tattoo on his head, and his name was Bill Smith, would it be a reasonable inference from the argument that the guy was big, that he had a motorcycle gang on his motorcycle? Would there be a reasonable inference that the defendant shot him because he was white?
I would argue there would be, and if the exact same facts, including during voir dire, if they had voir dire about a white supremacist motorcycle gang, if they had linked him to that motorcycle gang, and if the victim had been Hispanic, and they had said his appearance was terrifying, and yet all of the factors of his appearance weren't reasonably factors that would actually cause terror. Basically, this case is so similar because they're dressed the same. There's no other justification between them except for the elephant, or the code word, the elephant in the room, which is his race. And so I would argue that defense counsel was trying to otherize the defendant to make him appear scary, and
The victim, otherwise the victim.
otherize the victim, excuse me. And also that the defendant, when he testified, when he said that the victim's appearance caused him terror, if you can analyze the testimony, you can watch the video, and the jury can make reasonable deductions about that testimony, about what it was about his appearance that caused terror. And you eliminate all the other factors.
Given the sort of the history of our country with racial strife that we've all seen at least on movies, if not in person.
Yes, Your Honor.
What about the argument though that in light of all of that, that maybe the court should construe the due process clause to say there's a heightened burden before any party can inject something like, a person acted because of race in this situation. Is that not a reasonable position for the court to take?
I think the question in this case is it's an abuse of discretion question. I think the trial judge has a discretion to observe the entire trial and to observe the actions and the arguments of defense counsel, and the trial judge has to make that, and I think it's a very hard decision. I don't think there's a bright line, but I think in this case it wasn't an abuse of discretion.
Here? I mean, if the trial judge were to believe that the defendant was subtly, but nonetheless injecting race into the argument of why his client shot the victim, couldn't the trial judge, instead of allowing the state to respond by explicit and overt reference to race, to call out that use of the race card, just instruct the jury, ladies and gentlemen, you are not to consider the race of the victim or the defendant in anything you do here today?
That might have been a better solution, Your Honor, but the law does say in closing argument, if the defense steps out of the bounds of the record, the state is entitled to respond. That might have been a better way to.
The law says, what is the law?
Due process, Your Honor?
It's us, right?
I'm sorry, I didn't hear your question, Your
When
Honor.
you say the law says, is there a statute that says that?
That's case law says that the
It's
state is
just-
entitled to respond.
So we made that law, we can make different law, right?
Yes, Your Honor. You can definitely make different laws. I think the problem here is, in this particular case with sudden passion, the defense had the burden of showing that the defendant was objectively scared of the complaining witness.
Right.
And to use race to do that, I would argue would violate due process.
That actually, you're getting to a point that I'm sort of curious about. Like, I hear your argument about, well, here's this thing in the record that says we're talking about his appearance. And there's all sorts of effort to sort of tie him to a motorcycle gang. And so even if I accept that those ideas somehow inject race, I'm still left with the question of why on earth would the defense attorney try to say, you should not punish my defendant, my client, harshly because he's racist?
He's trying to say, my client was terrified.
My client fears a guy because of race. You
Because the
should
defense
punish
attorney
him less.
was trying to use implicit bias to say the complaining witness was scary.
Okay.
Therefore, he's entitled to a second degree. Therefore, the punishment should be 2 to 20. Therefore, as he asked in closing argument, release Mr. Kitchens, give him 2 years in prison.
So,
That's why.
so is the theory then, do we have to, in order to say that the state can rebut this, that we have to accept the idea that maybe implicit bias might validly feed into some sort of sudden passion argument?
I would argue due process would be against that. You
I would think so.
can't have implicit bias support it because there's an objective component to sudden passion. I think that was the whole problem. I think in the closing arguments, the defense attorney tried to conflate those two things by calling Mr. Kitchens an ordinary man and then saying an ordinary man would be terrified of the appearance of the complaining witness. He's trying to conflate the subjective and the objective. And I think there has to be some way the state stands up and responds to that, or the judge, or someone needs to respond to that, or there's gonna be a due process violation.
Sure. Is there any discussion in this case by either party about whether we need to add or discuss or consider a due process component to prevent this kind of thing from happening in the future? Or is it just whether or not the trial court abuses discretion in allowing the state to respond?
Are you asking me, was that briefed in this case?
I'm asking whether or not the argument in this case is simply whether or not there's an abuse of discretion on the part of the trial court to let this in, or are we actually tasked with trying to figure out what due process standard we should be applying to prevent race from being injected into the proceedings?
The issue in this case, I would say it's limited to whether the trial judge is the one that's tasked with determining where that line is. The trial judge is the one that's observing the arguments of counsel, can see the demeanor of the witnesses. The trial judge's job is to make sure that race is not injected into the trial.
Let me play with my colleague's question a little bit. How could we write an opinion that would tell defense lawyers how they can defend their clients? I mean, are we going to tell them what they can and can't say during closing arguments?
Your Honor, in certain instances like this one, there is not a bright line standard that can be articulated.
Right, but your argument is, if I understand it correctly, please correct me if I don't, is that the defendant was subtly playing race in the hearing and in the voir dire and to a lesser extent in closing arguments.
My argument as defense counsel, that was a theme throughout the entire trial. That was one of the reasons, if not the reason, that the defendant was subjectively terrified of the complaining witness, because the case law says words are not enough. The video says so much in this case.
Let me ask you this. Under the subjective prong of sudden passion, defense counsel could have put in evidence that this particular appellant was a racist individual, had a history with the banditos, and had a very high degree of fear of Hispanics, right? He could have done that.
Yes, Your Honor, yes.
If he had done that, it would have been entirely appropriate for the state to respond exactly the way it did here and say that this sudden passion defense is really based in his fear of Hispanics, correct?
Yes.
So what we're really dealing with here is whether, under the facts in this case, this particular trial judge felt that he had seen enough racial components here
Yes.
that the state would be permitted to make this argument. And that's a question of abuse of discretion at the trial judge level, correct?
Yes, Your Honor, I would agree with that. And I would say in this case, the defense attorney, that wouldn't have been an effective strategy because that would have gone to prove the subjective fear.
Sure.
That's fine, but it would not have proved objective fear. And so that's why the strategy is to be more subtle about it, to prove that.
Well, let me ask you this. So you've agreed that we shouldn't be injecting race at all.
That's correct.
Why didn't the state object to this argument on those grounds for the defense's argument and stop it right then?
That's a question, first for the prosecutors, but second, the way that this case unfolded, the way it was made through inference and reference, the term bandito, and then how that was referenced in closing argument by outlaw biker.
That's why I asked the question, how would this work in the real world? I mean, you've got defense lawyers, to their credit, can often be very bright, and their job is to take care of their client the best way they see how to do it. And you have somebody who's saying banditos, look at the video, look at the video. How is a trial judge or the state supposed to respond to that by saying, I want to in limine out the word banditos, or if he mentions the word banditos, I want a 5-minute recitation of it's not just Hispanic people that are members of the banditos, there's Scotch-Irish and there's et cetera. So how is that going to work in practice?
Well, I'll say two things. First, the state actually attempted to get in front of this issue by getting an motion in limine that was granted by the trial court for the defense attorney not to suggest or imply that the complaining witness was part of the banditos or an illegal motorcycle gang. That was violated in closing argument. So the state tried to prevent that with the motion in limine. That didn't work. And the second point is, I think, in how our defense attorney to know where the line is, they can read this case and see, well, in this fact pattern, this is crossing the line, and they have to look at other cases, just as we do with case law. You cannot create a bright line rule. It's up to the discretion of the judge who is there, who is observing the behavior of the defense attorney, the strategies to make their best judgment of whether race has been injected enough to violate due process and to basically entitle the state to respond, or for the judge to respond in some way. It's probably not best to have the state respond. I'm not advocating that. I'm saying in this case, with the facts we had here, it was an error, or at least the trial court didn't abuse its discretion in concluding that either it was a response to reasonable deductions based on the defendant's testimony about the complainant's appearance being terrifying, the video, and the fact that all the other characteristics of the defendant matched up and didn't support that, and also it was a response to counsel's argument, which is they're both proper arguments during closing argument.
So I'm kind of struggling to decide. You know, one of the difficult things about this case is the state argues that these different factors that the defense was pointing out led to a reasonable inference that, in fact, the victim was shot because of his race. So the claim seems to be that the defendant pulled the trigger out of racial animus, right? And I'm wondering about whether these same factors that the state claims led to the inferences that they're relying upon could also lead to other inferences that are equally strong, that this guy was just a big, scary guy who didn't belong where he was, and that his presence was threatening and made this person who ended up pulling the trigger in this instance legitimately afraid for what was going to happen next if he didn't act immediately in the way that he did.
Yes, John, I would say the argument from defense counsel is not that he shot him, or the implication that because he was Hispanic, is that he experienced terror. He was more scary because he was different. They emphasize how he's different than other customers. He looks different. He looks odd. He looks like he doesn't belong. Defense attorney during closing says he was somewhere where he didn't belong. That's why this shooting happened. I would argue it's the otherizing and the focus on the fact that he was different in his appearance. In this case, it doesn't have to be an Hispanic. It could be a white person in that situation. If you walk into a Hispanic shop, if the defense counsel made all the same type of references, I think you'd have the exact same issue, and the state would be entitled to respond in the same way, asking that race not be considered in the case. I think it goes both ways, and it's just, I think there is enough evidence. There's no, the hard thing about this case is there's no one point. They were careful not to say the word Hispanic. That's true. But they, in every other way, implied, they otherized him, and they said he's different, he's scary because of his appearance. And the jury is allowed to make deductions about what is so scary about this guy's appearance. They saw the video. They saw him interacting fairly pleasantly. They saw the complaining witness walk to leave, and then you can tell as they argue in closing, he turns around. Inference is that the defendant said something to him because the dog, for the first time, pops up and looks around. The complaining witness then turns around, takes his earbuds out of his ears, still standing there by the front door, and then you can see the defendant in a two-hand pose come forward, approach him, shoot him 4 times, he falls, and then he shoots him one more time through the eye. Right. And so The state's
But
position is,
there isn't this. He's not trying to assert that he acted in self-defense.
defense.
I mean,
He's
that's not what he's claiming.
he
here.
asserted that in the
He's-
first trial, and the jury
Right,
rejected
right.
that.
But he's already past that now. Now
Yes.
what he's arguing is that these circumstances led my passions to become so aroused.
Yes.
Reasonably so.
Yes.
Right. That's the real argument.
Yes, it's the reasonableness of it.
Hang on just a second. I don't read any reasonableness into the first subjective prong. It literally says that the defendant, in fact, acted under the immediate influence of a passion such as terror, anger, rage, or resentment. It literally says that can be,
Yes.
there's no reasonable component. So
Yes.
if the defendant wants to make race one of the reasons,
Yes.
reasonable or not,
Yes.
for his subjective terror or passion, would it not be due process for the trial court to prevent him from putting that evidence in?
No, the defense attorney is allowed to make that argument
Right, and if the
for the
defense
subjective
makes
component.
the argument that race is in some way related to his subjective sudden passion, does not then the state have the ability to rebut it? If the state is in a position where it feels that a reasonable juror might believe that race was a component here, is the state not able to do what it did, to caution the jury and say, do not let this defendant's racial prejudices become your racial prejudice?
I would say the defense is allowed to admit evidence of bias if it caused terror or fear for the subjective component. What the state was responding to was the defense attorney's argument conflating the subjective component with the objective component, saying that the defendant, is a reasonable person. A reasonable person would be scared of this man because of his appearance, for the reasons we've said, and that justifies sudden passion. Yes, he didn't say the word Hispanic. He said everything except for the word Hispanic, and the state responded to that argument.
Could we just craft an opinion saying the trial court abuses discretion because the argument was improper, but because the evidence of sudden passion was so low to be vanishingly small that we can't say he was harmed?
Yes, Your Honor, turning to harm, there's basically zero chance, taking this statement out of the record, that the jury would have given a sudden passion instruction. The only other question, because there's no adequate cause, I think we've established that, and the video establishes that. The only other question is, he was sentenced to 25 years, he didn't get 17, he got 15 years the first time. He got 25 years the second time. That is not evidence of this being tainted by that comment, and that's because there's multiple reasons. This is several years after the offense, so we hear that the victim's wife, she died as a result of this offense. She got addicted to drugs, was hit by a train. His son got addicted to drugs. He was the sole primary breadwinner, so they lost their house. Lots of tragic consequences the first jury didn't hear about. But more importantly, the first jury never knew that the defendant was aware that there was a machinist matching the exact description that the complainant was looking for that worked right across. The first jury never knew that. The second jury, it comes out in cross-examination that the defendant knew what the complaining witness was talking about. Then he knew that the person matching the description was just across the street. He just didn't tell him. So his fact that he was terrified because of the complaining witness's confusion and frustration, and the fact that he wanted him to just leave, is completely not believable, because he could have just pointed him across the street.
Counsel, thank you. I believe we have your argument. I appreciate it very much.
I apologize for taking too much time. I appreciate this court. Thank you.
Good morning, I'm Stanley Schneider. Judge Finley, there's no evidence in the record of Will Kitchens being biased against Hispanics. There's no evidence in the record of racial motivation in this at all in this
Let me
case.
rephrase that question then. Is it your position that no reasonable juror could have concluded that race may have played a role here?
None.
Your position is no
None.
reasonable juror could have
None.
concluded that?
It wasn't in the record. It wasn't discussed. The three witnesses who were in the shop all described the man as a big, burly guy who didn't belong in a shop that worked on Lamborghinis and Maseratis and Jaguars. That was not the issue. The state has misrepresented the record. The state in trial said they were commenting on the deceased's race, and only about the deceased's race. He said, "I'm commenting on the race of the complainant." But actually what was said was, he talked about he had facial hair, he was scary. They're all just saying he was scary because of what? He was scary because he was a Hispanic guy. Now, When he said he was scary because he was a Hispanic guy, that invokes racial bias.
To be clear, that's the state making that
That's the
argument.
state's argument.
What they said was, what the state actually said was, what they're not saying is that he was scary because he's a Hispanic guy.
They're all just saying he was scary because of what he was saying because he was a scary guy. And they have said before, just before that, he said, there's something that we haven't talked about.
Well, the direct quote is, are just saying was scary because of what? He was scary because he was a Hispanic guy. That's what they're not saying.
So,
But that's
so when the phrasing there, though, that doesn't mean that like, oh no, I'm not saying that that's what the defense's argument is. I'm specifically saying they're not really saying that.
If that's really what the reason he shot him, that's the real reason he was afraid of him, was because he was Hispanic. And Will Kitchens testified. If the state wanted to explore his racial bias, if he had any racial bias, they could ask him questions. They could have gone into it and say, let's talk about his Hispanic background. But they didn't do that.
Counsel, let me ask you a question. Explain the difference, if you see one, between the state basically saying the defendants are racist versus saying, hey, don't discount the punishment here because the victim here is Hispanic.
That's what they're saying. They're saying he's a racist. That's what the accusation is.
Is saying somebody is a racist, this may be a stupid question, but is saying somebody is a racist injecting race into it? Or is saying somebody is a racist just saying he's a really bad guy and you should give him all the time?
Is it the difference between a juror believing that Will acted out of fear and shot him out of fear, or shot him because he was a racist? What's the difference? Would that shove it over the line between 20 years and 25 years?
But wait a minute, counsel. Again, we've got a subjective and an objective, right? To me, it seems like what the state is arguing is effectively whatever you believe on his subjective reasons. As to objective, we, the state, believe he was shooting at this guy in part because he was Hispanic, and therefore that's not objectively reasonable.
Judge, you have to have evidence to make that accusation, and the due process clause forbids it. Judge Parker, there is no case on point. However, the Supreme Court of Texas in Alonzo versus John addressed this very issue just last year. And in that case, a plaintiff's attorney said, and I'm paraphrasing, don't diminish your award of damages in this case because it's a woman who's black. And that injection of race, everyone in the courtroom saw that the plaintiff was a black woman, but they made it a part of their arguments and made it a part of why they should increase the amount of damage.
Okay, but the issue here, effectively, was the reaction under this provocation reasonable from an objective perspective? And if, given this fact pattern, a part of why this was done was in fact that the appellant was racist, it would be entirely appropriate for the state to address that.
Well, if in this describing what happened, Will said he was a big Mexican guy.
That the state's trying to undermine the objective prong, correct?
He's trying to undermine the fear expressed by...
And the state's argument is his actions were not objectively reasonable, in part because his actions were driven by
racial bias.
Pardon me?
By
racial bias. Okay, and if the state is appropriate to undermine the objective prong, for instance, if the state had evidence of clearly racist conduct of the appellant prior to trial, would they not be able to put that evidence in to undermine the objective prong?
Maybe, depending what it is. Okay. Depending what it is, Judge.
Forgive me, but isn't our problem here that we're looking at this after the fact? Let me take you back to the Texas Supreme Court decision on don't diminish the award because the plaintiff is a woman of color. The problem is, what does the trial judge do?
Well, the trial judge the state didn't address the word scary. He was afraid of him because he was Hispanic. And I'm talking about they're attacking Will Kitchens, the state saying, oh, I'm making a comment about the complainant's race. And so the court went with what the state's explanation.
You heard my question a few minutes ago about what's the trial judge to do if he thinks, and I know that you're saying it was not the intention at trial, but he thinks the defense has been hinting at race by, for instance, emphasizing the Hispanic surname that the defendant did not go by, the decedent did not go by, or the banditos, et cetera, et cetera. There will be more difficult cases than this one for us to deal with. What standard do we come up with to tell a trial judge he's got to act to diminish race coming in first from the defense?
I think you have to look at two cases. Look at Alonzo, the Supreme Court's decision, and you look to the Chief Justice Roberts' decision in Buck versus Drecke. Race plays no part in a criminal trial in Texas.
Don't you think it can? Because membership in certain gangs is race related.
Well,
so how can we totally exclude it?
If you're charged with a hate crime, like the Byrd case up in East Texas, where race was the center point of the trial. Here, if you're charged with a hate crime, that becomes part and parcel of an element of the case. If they thought that Will was acting out of hatred and bias, then that's an issue. But in Buck versus Drecke, evidence was introduced through a Dr. Chiano that said that blacks and Hispanics were more apt to commit future acts of violence. And there was no objection. Or in Buck, it was the state, the defense called Dr. Chiano, and the state introduced that evidence in cross-examination. Over 20 years ago, I stood before this court with John Cornyn at my side. And Senator Cornyn at that time was Attorney General, and he asked this court to create a bright line that evidence of race could not be introduced at punishment of a trial in Texas. The court said procedural default applied and ignored it. The federal district courts reversed this court. This circuit upheld that reversal. The Supreme Court of the United States in Buck said race should not be allowed at the punishment phase of a trial. A bright line rule.
But how would that bright line rule work? Go back to my example. If this defendant, in attempting to meet the elements of the subjective standard, did want to put in evidence that he was experiencing sudden passion because of his own racial prejudice, the court would have no business excluding that.
Judge Finley, you can talk about the hate crimes. This is not a hate crime.
All right, let me change the facts a little bit. The defendant is African American from East Texas. He has 2 or 3 gentlemen walk through his door who are from members of the Aryan Brotherhood, swastikas, et cetera, gunplay. Several of the Aryan Brotherhood are down, dead. We're in a punishment phase of that trial, and the defense lawyer wants to bring up the Aryan Brotherhood membership. How does a trial judge not conclude race has been injected into the proceeding? What is a trial judge to do with that situation?
Well, let's say if I'm standing in that situation, a Jewish man, seeing people come in with swastikas on their sleeves, I'm immediately going to be afraid of the swastika. I'm going to immediately be afraid of the tattoos of the swastika because of my fears of what happened to my family.
But you're telling me a white bald man or 3 young white bald men dressed in Southern paraphernalia wouldn't immediately trigger your defensive response?
I'm scared to death.
Because of their appearance. Because they're white, bald males.
But your defense lawyer is going to want to bring it up at sentencing, isn't he?
I'm going to talk about, as I did in this case, I talked about his size. I talked about the way he came into the place. I'm going to talk about
ignoring the elephant in the room. I mean, you're totally ignoring the elephant in the room because in a lot of these gangs, race is related to their membership in the gangs. So
every bandito I've represented none of the banditos I've represented were Hispanic.
I'm not talking just about banditos. We can talk about
Some
Crips,
gangs-
Bloods, Aryan Brotherhood. I don't know, when was the last time you saw a black guy in the Aryan Brotherhood that had swastika tattoos on it?
And that's,
It was on Oz, I think.
I think we're getting far afield. The issue here,
I'm not sure we are. He's got a point. Look, in an ideal world, race would make no difference. But we don't live in an ideal world. We live in this world. And in this world,
That's
race
John Cornyn's
makes a
argument.
difference.
You're repeating to us, right? You want this bright line, but we can write a bright line. But the poor trial judge has to live with it and decide when it's being crossed and how to deal with it.
the bright line is if there is evidence, and the judge's duty to decide what could questionings be asked. Was it about him being afraid of Hispanics or racial acts toward Hispanics? Is that admissible at all? And there was nothing in this record about that.
Well, except for voir dire, right? With banditos. You're saying banditos is not Aryan Brotherhood.
Well, SYLB, at about the time of the trial, there was trials going on in Waco about a shootout between banditos and another gang. And there was publicity all over the place about outlaw bike gangs throughout the state. And that was a big topic in the media. And so I'm thinking
But
media attention.
SYLB is support your local banditos.
That's why I wanted to introduce that, blow up that picture of that on page
And the
5.
trial judge made an attempt to exclude that, and in fact did exclude it. The state,
And it did.
the state
Excluded it, and
blurred that out.
And they excluded the issue about him being a member of a gang, of a motorcycle club from San Antonio at the same motorcycle. And the descriptions that were given in the trial were a big guy, didn't belong in our shop, not a normal customer. He was a big burly guy who outweighed Will by over 100 pounds. The last words he said to him, according to Will, was, "I'm going to fuck you up right now." Those were the words before the shot.
Wait a minute, I thought those words were then repeated back by the appellant.
No, those are the words spoken by the soldier.
And the appellant did not then repeat something
That's
similar
what
back
he
to him?
Counsel,
Right, when he was shooting.
we've pulled you a little bit afield. We're over on time. Why don't you take 30 seconds, if you would, and wrap up. Tell us if there's anything you think we've missed that we need to hear.
I think in this case, because the state accused Will Kitchens of racial bias, he's scared of him because he's Hispanic. That injection of race violates the Constitution, it violates due process. It conflicts with Buck versus Drecke. The Supreme Court's decision in Alonzo is right on point, and this court should follow the Supreme Court and say that arguments like this, when there's no evidence in the record, is prohibited. And that's what this case is about. There's no evidence. The introduction of race was prejudicial, and it's a bright line that should not be allowed.
Thank you very much. A
Thank
very
you very
fine
much.
argument from both counsel. We're going to take a brief recess for about 5 minutes, then we'll come right back. Thank you very much. Please be seated. I'll now call our second case on the docket today, number 052221 through 052521, ex parte Robbie Gail Sharrett. We'll hear first from counsel for the state. If you could state your name when you begin, it would help. Thank you.
Good morning. My name is Stacy Soul, the state prosecuting attorney for Texas. And Judge Shank, I just want to acknowledge your request about the background, and I'll get to that.
That would be helpful. Thank you. Yeah.
We're here today because Texas law allows two methods to enforce election offenses. The first being the civil administrative process, which is through the Texas Ethics Commission, commonly referred to as TEC. And the second is a criminal prosecution enforced by a prosecutor inside a court. On original submission, this court erred to hold that TEC has exclusive jurisdiction over a criminal prosecution. And I want to go back to why we're here today. Ms. Sharrett was charged with various election offenses, one including representing herself as a sitting judge on a campaign sign when she wasn't. We are in a pre-trial posture right now, so Ms. Sharrett has not been convicted of any offenses. She's just simply had faced an indictment in this case. In challenging that indictment in the trial court, she claimed that her prosecution was premature because the offenses had not been looked at or ruled on by TEC first. This case is unique because we're here on rehearing. In September of last year, this court issued a decision in this case, holding that TEC did have exclusive jurisdiction and agreeing with Ms. Sharrett's arguments. I very much appreciate the court granting rehearing in this case, and I want to explain why I think rehearing is warranted. In 1974, when Texas enacted its new penal code, probably no longer new because it's 50 years old at this point, this court recognized that defenses to criminal conduct must be statutory, must be expressed and given by the legislature. So that wiped out any common law defenses that pre-existed, something like alibi. In this instance here, the court says that a prosecution is barred or potentially barred, and that subject matter jurisdiction is displaced, and in doing so, it treats subject matter jurisdiction and prosecutorial authority less than it treats defenses. And they should be treated the same. This court should require express authorization from the legislature to impact court jurisdiction and prosecutorial authority.
Counsel, let me push back on you a little bit here. You submitted a very fine brief, and I appreciate it very much, but you seem to be in two places be presenting us with sort of binary choices. This is about jurisdiction or exhaustion. This is about power of the prosecutor or power of the district court. But is it, in fairness, is the original majority opinion that limited? Isn't really separation of powers part of what's driving this concern?
It absolutely is. And that's why I think that the court in criminal cases in particular, if the doctrine of exclusive jurisdiction is going to be recognized in the criminal sphere because of the encroachment on prosecutorial authority, it should absolutely have to be expressly.
But that's not so limited, because you have us looking to what the statute says. There's going to be lots of settings, and this could be one of them, and I want you to get back to that. But when you look at, we've had a couple of things happen since you were first here, or whoever was here in your place.
Absolutely.
Trump versus United States came out. This court, going back to Perry, which was cited to us at least in the original petition, has taken of you, and we are unique in Texas, are we not? And that you and your friends are in the judicial branch with us. We hear your cases, we decide who wins and who loses, and there is particular potential complications from that fact when we reach out into areas where the Constitution assigns authority to the other branches, right? And in this, as you pointed out in the exhibits you gave us, the Texas Constitution puts the Election Commission in the legislative branch, and there is the potential, is there not, for judiciary, meaning you and us, to step on their toes in ways that would create a constitutional problem that's completely distinct from anything that may or may not be present on the face of the statute.
The constitutional authorization for TEC only provides for the formation, how the appointment process is going to go, and the compensation. It doesn't exactly say what TEC is going to do.
Oh, I'm with you that far. My concern is the way you're presenting, at least in your brief, that it's a jurisdiction or it's exhaustion, power of the prosecutor or power of the court. They're both the same thing. They're the power of the judiciary. And if I were to follow you there, we would have potential constitutional settings like you had in a Perry case, for example, or you had in a Trump case. And it's not hard to come up with examples. You can have a prosecutor, we have 254 of them in this state, who would say, for instance, I don't think the police should be allowed to have guns. I don't believe I like the way that the executive branch is training police officers. Right? And then you have the potential for the judiciary pushing in to counteract the legislature or to counteract the place of the executive department and how they train people. Right? Isn't that a problem potentially that the majority opinion was addressing here?
I absolutely do not see that problem. I do not see any part of that statute that is meant to encroach on criminal enforcement of election offenses. TEC simply has jurisdiction over civil enforcement.
But if it were that binary, if it were just, the statute doesn't say it's exclusive civil jurisdiction until they decide that it's not. If it said that, you would concede, you would have a very different argument here today.
I think then we would need to get into
totally
separation of powers.
And totally driven by statute, which is where I'm not accepting the limits that you're putting on the argument. But what would we do, hypothetically, if the Election Commission were to send a letter to whoever the district judge is here saying, we have a very sensitive civil investigation going on right now, would you please back off? What would we do?
I don't think you have any authority to do anything, and nor do I think that that TEC has any authority to ask you all to withhold anything. You have the prerogative to run your own docket.
There are abstention doctrines all over in the federal system, are there not? I mean, they deal with these problems, federal to state, intragovernmental conflicts between the administrative or the executive branch and the judicial branch. Maybe we don't have that problem here, but that's a separate problem from what does the statute say?
When you talk about the abstention doctrine, that usually involves a political question. And I don't see this as a political question because I don't see the legislature giving TEC any kind of law enforcement authority over criminal offenses at all. And in fact, the statutes read to expressly provide where any action by TEC can come into any kind of calculus with a criminal prosecution, and those are for expressly provided defenses to prosecution.
The statute does authorize TEC to make referrals for criminal prosecution, right?
Absolutely. And that is a matter of notice, but it does not mean, and nor does that say, that the prosecutor doesn't have authority to prosecute at all.
Counsel, is the argument that's before us essentially the same argument that the state brought the first time? And we issued an opinion in Sharrett, and now you're asking us to reconsider?
It's somewhat different because even though Ms. Sharrett's claim was presented as a premature prosecution for not going to TEC, the idea of the exclusive jurisdiction doctrine did not come out until this court's original opinion.
Okay. All right.
And that's why we're here on rehearing. This is a bit of a different posture. It was certainly the first time it's been applied in a criminal case.
Okay.
So does the TEC, do they have different or perhaps more extensive investigatory authorities than do law enforcement?
I can't compare because I don't know how TEC operates internally. I would say, having been in this situation before, that perhaps if the court suggests that TEC answer a narrow question, that they might be willing to file an amicus, but it is something that could be asked. I don't know what they would do. I have no authority over them. I know what law enforcement's investigative authorities are, but often these things are very different, and I can give you the example of a revocation hearing where this court has said that the same facts that have been presented in a revocation of community supervision hearing don't bar a later prosecution based on those same facts, even if they were not found true within that revocation proceeding. And the idea is that depending on the level of enforcement, like a revocation hearing, which is a lower burden of proof, that the state may offer different evidence. It may not offer its best evidence. And the two entities, being TEC and the prosecution, because they largely operate in private when they're undergoing their investigations, there's no guarantee that one knows what the other one is doing at the same time.
Well, I think the curious question that is at the heart of this case is, we're trying to, first of all, understand the meaning of the statutory language that was given to us by someone else. And inside that statutory language, they provided that the Texas Election Commission has the ability to refer cases to prosecutors for prosecution. So it seems like implicit in that, maybe, you ask yourself why, what is the purpose of providing the opportunity for the TEC to refer these prosecutions? It could be, on the one hand, what the court said in its first draft opinion in this case, that you simply can't prosecute unless that agency gives you the authority to go forward by giving you a referral. Or perhaps it might be because there is some things that the TEC might find out that normal law enforcement just won't encounter on a day-to-day basis. And so the way that they will find out about those potential criminal activities is to wait and hear from people who are involved in that area, who will then refer it to them.
So first, looking at that referral language, that is something that directs TEC to do something. It doesn't prohibit the prosecutor from doing anything.
Okay.
And it's usually very much against this court's case law to go in and rewrite a statute.
Right.
Okay.
It's not that we haven't done it before,
but
we're not supposed to.
But these are very different entities operating with very different rules. And so, for example, one thing that limits TEC is if it comes to their attention that a complaint was filed by somebody and urged by somebody from out of state, no matter what point in the proceeding with TEC has to dismiss that complaint. That is not the case for a prosecutor who may gain information about a criminal offense from somebody outside of Texas. We're operating on two planes. And I want to point out,
Real quick.
Yes, Judge.
Is it your position that a candidate or a politician could be subjected to both prosecutions, or whatever you want to call them, at the same time by both agencies, the district attorney's office and TEC?
Yes. One of them has nothing to do with the other. And I want to start with where the court left off. And the state was left off with the fact that the indictment was dismissed in the case. Nothing was said about what is supposed to happen next. And so I think looking at what could happen next or can't happen next should inform this court's decision on rehearing. So this court, or anybody really, doesn't have the authority to require 6 TEC commissioners to vote to take up the action on their own initiative. Nor does this court have the authority to order a Texas resident or property owner to file a complaint. That is something independent and outside of this court's authority. The statutes also don't seem to contemplate the defendant filing a complaint against herself. So we need an on-ramp of how do we now, if the court's opinion is correct, get before TEC. And there's some very strict limitations here. And asking a defendant to also to go before TEC, there's definitely some irony from this position because a criminal prosecution would not be precluded by any action that TEC takes, is that it is only subjecting her to secondary liability before an administrative agency, in addition to a criminal prosecution. And right now, this court has another rehearing pending in Ex parte Stafford, which dealt with the true source provision and held that it was unconstitutional.
Let me ask you a question about that.
Yes.
If you're right, we actually lack jurisdiction here, right? This comes to us as a pretrial habeas. If you're right, is there a jurisdictional defect? Is there a constitutional or fundamental right? If we go all the way back to the beginning, if you're right, do we have jurisdiction here?
I would say it's a non-cognizability question.
You would say what? Sorry.
Non-cognizable question?
Yes.
Because it's not cognizable on a pretrial writ.
Exactly.
Isn't that what the lower court said too? That this
Yes.
was not, so we could just go back and say, well, we agree with them that this wasn't cognizable.
But there's
Yeah,
another way for you to win, right? The writ could be cognizable, but she launched, as I understand it, basically a facial attack to the entire scheme, that there's no prosecution that can be brought unless TEC pre-clears it effectively by referral. But there's another potential attack of, yes, you're here to challenge properly whether this prosecution is stepping on the toes of another branch of government. Who's in this case?
I think they're both kind of wrapped up in the same thing. And so, you know, if this is a Perry-like claim, and I just want to finish this thought if I can, Your Honor. I see my time's up. If Perry-like claim that would completely bar prosecution, then it would be something cognizable. But of course, we are very much disputing that.
But my point is, and you're right, but assuming for the sake of argument, we don't have jurisdiction because it's not cognizable. Given that in Stafford, we ruled 255-004B was facially unconstitutional, and Sharrett was charged with a violation of 255-004B, would we not at least still...
She was actually charged under a different subsection.
Was she?
Yes.
All right, so she wasn't charged under 255-004B?
She's charged under A,
Okay.
which the court hasn't ruled on. But I can imagine that the defendant in Ex parte Stafford who got relief would be very disappointed, having vindicated his claim of having this court dismiss it for one of jurisdiction and now having to go before TEC and start the process all over again.
Counsel, I believe you've reserved 5 minutes for rebuttal.
Thank you.
Thank you so much.
May it please the court, Lewis Thomas on behalf of petitioner Robbie Gail Sharrett. I'm from Houston, Texas. The question here is twofold. Does TEC have jurisdiction over the charges that were brought against Ms. Sharrett? And if so, do they have exclusive primary jurisdiction to decide those matters before any criminal prosecution can be brought? This court, in its opinion in September of just last year, said yes to both of those questions, and the court was correct at that time. I'd ask the court to consider this hypothetical. There are two counties. One, we say Harris for hands-off policy by a prosecutor, and one, let's call this hypothetical county Travis for a tough prosecutor position on these type of campaign finance cases. Hands-off Harris County refers all of its cases of this kind that are under the exclusive purview of the TEC to the TEC for preliminary review. Tough prosecutor Travis County decides on their own every time they see a filing such as a campaign finance report, which is one of the reports at issue in this case, or a personal finance statement, which is a reported issue in this case. They immediately observe that that report is late, contains improper name and address of contributors to a campaign, or somehow misallocates funds that were spent by a candidate, Tough Travis can immediately, with his or her investigator, file a complaint in front of a justice of the peace and have any person, for example, the members of this court, arrested for late filing or a lack of filing on a campaign finance report. Harris, with hands-off policy, instead refers all of those cases to the Texas Ethics Commission, who then reviews the sworn complaint, determines whether that is a Category 1 or Category 2 violation. For example, if an improper address is omitted from a campaign finance report, or if a personal finance statement, for example, in this case, was filed perhaps a week late. Those are the criminal offenses that we are here in front of all these folks that you guys have spent your time on, and we've been here since 2018 dealing with. This court took 2 years to resolve from 2022 to the issuance of this opinion. So I know, and I certainly don't know what happened behind the scenes, but I know that this court spent extensive reflection and review of all the statutory sections at issue here, and this court arrived at the correct conclusion.
Counsel, Counsel, Appellant's position that the legislature in 1991 intended to and did create a pervasive regulatory scheme in the TEC. And is it also Appellant's position that for 20 years the legislature just didn't realize that it wasn't being carried out that way?
I think the answer is no, and the reason why is this was discussed at the trial court and at the 2022 argument. There are over 1,000 sworn complaint orders on the TEC website for cases of this kind, where parties were brought before the TEC and resolved these types administratively through the process. It's been made known to me that there are other cases that have been charged in Harris County, not Harris County, but in courts of this state. And so I know there are cases where prosecutors have chosen to go ahead with these types of crimes, but it's so rare, which is the reason there are no reported cases under these
I hear you,
statutes.
but my question is, if the position is correct, that the legislature intended to and did in 1991 create a pervasive regulatory scheme.
Yes.
But for 20 years, DAs felt free to prosecute, and nobody in the legislature said, you know what, turns out they're not enforcing this the way we expected. Nobody raised the issue, this court didn't address it, nobody made a credible argument that, hey, wait a minute, DAs can't prosecute this criminal law. Right. How is it that the legislature sat by for 20 years while the statute was misinterpreted?
Do we think they were paying attention?
I don't, and that's the thing is that, and Judge Finley, with respect to your question, I think when they wholesale created the TEC in 91 after the constitutional amendment, they took out very specific, and we brought this up last time in the argument, is that there was very specific language that showed how the complaint process worked kind of hand in hand with the prosecution, and that was chapter 256. That was completely omitted when they enacted the 1991 legislation. It seems to me that, and this court has talked about principles of statutory construction. When a legislature acts and removes language, that they're presumed to know why they've removed the language, and that language is no longer.
You raise a good question. Should this court give any weight to Senate Bill 1220?
Is that the newest?
That's the one that addresses this specific issue that does not have.
I mean, I think, well, at this point, it's not a law, so I can't anticipate the court.
Before it's enacted, I'll give you an answer to that.
Well, certainly.
But let me ask you a little bit different question. Let me take you back to your two hypothetical prosecutors, our softy in Harris County and our nail-chewing Travis County DA who wants to bring these cases. Isn't that an authority that the Constitution conferred on district attorneys, and the prospect of somebody being tough in one county and somebody being soft in another sort of baked into the cake? And does our original opinion and your position in this case take a howitzer to shoot at what is potentially a mouse instead of, as I was suggesting to your friend opposite, a more subtle and careful approach to, yes, the DAs work in our branch and with us, and there is the prospect for them potentially stepping into a pervasive or semi-pervasive regulatory scheme, or bringing us directly into conflict with the exercise of a core power of another branch of government by indicting somebody for threatening to veto or something like that. And the solution here, instead of your broad attack on no DA can bring any election case unless the Ethics Commission says so, is to just allow you to bring a pretrial writ like that and then ask for the proof. Where's the conflict? How is it that this prosecution is interfering with the operations of the executive branch?
Because...
Or I'm sorry, the legislative branch.
Right, and I see it does have an identity crisis as far as what kind of agency they are. They've identified themselves as an executive agency in their filings, but they certainly, Article 3 is legislative. So...
Well, they put it in the legislature. I mean, the Constitution says so.
Again, there's litigation that they've held themselves out because of their functions are executive in nature. But I'm not certainly here to defend that. But my point is, the legislature can, and I think did in 571, give them the opportunity or the authority to enforce and administer those laws, the specific narrow laws that we're here about. And also in Chapter 571, they created that the non-delegation statute where they can't delegate certain powers, and one of those powers is the power to refer cases to prosecutors. So there are other statutory schemes in Texas that also operate in exactly this way, and we talked about in our brief the TCUQ with the water code, certainly more express, and I'll consider that every time. My point is, I don't think there's any problem with an agency making a preliminary determination, and that's all Ms. Sharrett's asking for in this case, is that they make the preliminary. 6 of you guys think there's enough here to refer it to a prosecutor for prosecution, and so I don't. There's nothing absurd
about
about that.
Subject, let me just interrupt you. What if it's on it and the statute of limitations approaches? Does the DA have authority to step in and say, we've waited long enough, we haven't heard from you, we're going to go ahead and take this to a grand jury?
And I would say, just logically consistent with that position, the answer should be no. And the reason is because the scheme, again, for these narrow kinds of cases, we have 6 people who are nonpartisan from bipartisan from both parties that decide this is worthy of referral or not. And since the court's decision
I understand what you're saying, but by sitting on it for a certain period of time, they effectively prevent the DA from doing anything, even if they ultimately decide to refer it. At some point, does the DA have the authority to step in and say, we're going to prosecute this, it's been sitting in TEC for however much time, they haven't done anything, they haven't referred it, we haven't heard anything, they have no obligation to finish it within a certain period of time, we're going to take this over. Do they have that authority?
No, because TEC has that referral authority that is not delegated.
Is that always the case? Is it always the case that anytime you see that some agency is given referral authority, that necessarily means that agency has veto power over whether or not a prosecution goes forward?
I don't think that that's a common theme at all, but I think that it's important to see this in the lens of elections. I mean, we're not talking about whether an agency can decide whether a aggravated robbery or a murder case can go forward. We're talking about whether a campaign finance report that is on a form that is created by the TEC, that is subject to their rules and the timing of how it's filed and the contents of what's filed. Those are lobbyists, we're not a lobbyist, there's no lobbyist in this case, but those are the kinds of cases that we're talking about, is like whether things are registered properly, whether paperwork has been filled out properly. So in a particular, these are administrative paperwork type of cases.
Mr. Thomas, if I could interrupt you to follow up on Judge Yerry's question. When you look at the election code, section 253, 134, okay, in response to what your argument has been, it says that Title 15 does not prohibit the imposition of civil penalties by the commission in addition to criminal penalties and other sanctions imposed by law. So that implies that you can have a civil prosecution and a criminal prosecution happening at the same time. So that doesn't indicate to me that there's exclusive jurisdiction. How do you address that? Right there in the election code.
Of course, and I agree, Judge Parker. I would suggest that it's very much like the case where a person is assaulted and there's a tort and there's also a criminal prosecution. The TEC receives a sworn complaint from a prosecutor or a citizen of the state. They decide that this case is worthy of referral. That section, in our interpretation, simply means that the TEC could also pursue civil penalties against the person, including the fines that are, I think there's a schedule that the TEC has.
That would mean that the prosecutors could proceed with criminal prosecution, and then that TEC does not have exclusive jurisdiction, is the way I read this. Is that not the way that's...
No, not at all. I think it simply says that both of those things can exist. The fact that a referral would have occurred doesn't prohibit TEC from going forward and assessing criminal penalties or civil penalties, including, in that case, the Texas Attorney General could seek to enforce and collect any statutory fines. And so it just simply says, we're going to say you're free to prosecute prosecutors, but we're also free to impose whatever civil penalties that we think are immediately also
So do you
available.
think it takes an expressed statement by the legislature to take subject matter jurisdiction from the district courts?
No, because the Texas Supreme Court has in multiple instances determined that agencies that have pervasive regulatory schemes have the implied powers to carry out those schemes.
In a civil context.
Well, that's from the Texas Supreme Court, yes, but I agree that I think that's the principle that we're examining here, is whether that principle should apply in this case.
But
and certainly there is no express jurisdiction.
To the separation of powers concerns I've been focused on around the original opinion, which I see as a weakness with your other side, is potentially a very serious weakness with your side, because putting aside the statutory language, what you're urging and what the majority, at least in part, held originally was that what the legislature has done is arrogate unto itself the power to create a commission, to place it under its power to populate and its power to adjudicate. That's a concentration of powers, not a separation of powers, right? So we have a role too, and district attorneys have a role, and I respect the concern that there can be circumstances where the judicial branch is pushing in ways that create unnecessary conflict, but your construction is there is no role, if I'm understanding correctly, other than a legislative role for any enforcement of the election laws in the state, unless the majority of the nonpartisan members of the Election Commission agree to pre-clear it.
So I want to make it because the reason that we're here today versus last year, obviously we have a new court. And the election laws of this state are much broader than what is covered by the TEC. Extremely, there are multiple sections that are not Title 15. Has nothing to do with the conduct of voting, the conduct of the elections, right? Any of those things are separate. TEC has absolutely no power. But what I'm saying is that the legislature can simply create preconditions for a criminal violation. And
Why wouldn't they have just said that then? That doesn't appear in the statute, what you just said.
I agree that there's no express language like there is for TCEQ, for example, but the effect of a sworn complaint and that whole process that exists, the idea that a person who, let's say any person makes a sworn complaint with TEC within 60 days of an election, they can't even refer that case because of that 60-day sort of blackout rule that they have in the statute. That purpose is completely ineffectual in this case. And My point is that this actually creates it gives prosecutors the ability for election interference by picking winners, where the idea of the statute is not to pick winners in a primary for either party. The idea is to promote transparency and promote, to allow people to vote for who they think
The
is
prosecutors are answerable to the voters. The TEC isn't. Is it good policy for something as critical to the people's confidence in democracy as election integrity and the reliability of our election? Is it good policy to remove the ability to enforce those laws from the district attorneys who've traditionally had it, who are answerable to the voters, and vest it in some appointed group that is not in any way answerable to the voters?
I'm going to say yes, because...
I figured you would.
Because...
They're answerable within 254 counties, right? I mean,
well,
within their own
certainly,
jurisdictions.
But for the particular candidate or office holder that is the target of that particular prosecutor with their, whatever their whims are at the moment, I mean, we all watch the news, I expect, and since 2016, we've seen political prosecutions on both sides, I think, erupt in this country in a way that people, I don't think, anticipate or want.
But aren't you saying you don't trust the process, the district attorneys being answerable to people, having the discretion to enforce the laws?
What I'm saying is there's a statewide agency that is their task not only with creating these forms, creating the regulations that go with the forms, and creating the, you know, the whole process about how they get adjudicated. They also have the expertise to know what is an offense that is worthy of prosecution, in the sense that a particular, let's say, you know, a county that has no experience with this, they don't have that. And so the Ethics Commission is literally inundated on this on a, monthly, daily,
But if
weekly
there's
basis.
anything that every county has experience with, it's voting.
Yes, but the particular rules of a particular finance
So
report...
then, as an extension to your argument, if the legislature chose to create the murder commission and prohibited any prosecutor from initiating a murder prosecution prior to the murder commission evaluating and referring, the same arguments you're making here would underlie that.
I suppose they could give that power to the Attorney General or something like that if there was a constitutional amendment or something like that.
So, Mr. Thomas, you're recommending having bureaucrats decide these criminal matters versus elected DAs?
I don't think they're bureaucrats at all. These are people that are appointed by the governor of this state, by the Speaker of House, by the, I think one of maybe the Lieutenant Governor, I forget, there's 3 different elected officials in our state, the highest elected officials, that appoint these folks from both parties.
Doesn't that give you concern when you're talking about the problem with overreaching during and reaching into and having an influence on an election? You have a statewide agency that's very powerful. They have the money that comes from the state. They're funded by the state, and they're overreaching into, say, my county, McLennan County, or into another county, and undermining the will of the people, the elected DA of that county.
I don't think it undermines, I see my time is up, may I respond?
Yes.
Okay. I don't think it undermines the will of any person, because, again, those persons that are on the commission are appointed by the governor as those are, and that's an elected official. There's certainly a layer of accountability even with the administrative agency. So if those commissioners are not asked to reserve, they don't continue to serve. And I think that's a familiar posture for administrative agencies across Texas and across our country, versus the danger that the court would have if we have a local elected official putting their thumb on the scale for one candidate or another, or against one or another elected official.
Isn't that the legislative body telling the prosecutors what you can and cannot do? Isn't that problematic in and of itself, because you have this concentration of power?
Respectfully, Judge, I think that, again, our only position is that they've created a precondition to prosecution, which is the referral process.
That's a very powerful position to be in.
But I think appropriate because of the sensitivity that a criminal arrest and indictment of a defendant is in a context like an election.
Counsel, thank you very much for your very fine argument. Appreciate it very much. We'll now hear 5 minutes of rebuttal.
Thank you.
It's the criminal prosecution. Do you need me to repeat that?
Say that again.
Yes, I said TEC is not meant to be the tryout on the road for the main event, which is the criminal prosecution. And Judge, I understand your position of being sensitive about encroaching on the legislature, but this court deals with separation of powers issues. This is the bread and butter of what the judiciary is there for, to decide these weighty issues. I don't think it has to go there if it goes to rely on the fact that we must have exclusive jurisdiction, because I think that that is supported by the language of the statutes, which the legislative branch has enacted.
You heard me ask the question, are we open to business to hear there's a potential conflict you're bringing us into? What I was looking for is where is the conflict here by bringing a prosecution under the criminal provisions of the code with the operations of the legislative branch? And we might have that in a different case, or maybe we have it here. Could you explain why we don't?
I mean, maybe I'm not understanding your question, but the offenses that TEC enforces are the same offenses that are enforced by a prosecutor, just they are enforced in different ways.
Yes.
Counsel?
Yes.
Is your position that the legislature can or cannot decide to centralize authority for prosecution of, say, election crimes in a centralized, or are we constitutionally required to leave that authority with the local prosecutors?
I think that that's a question for another day, perhaps with TCEQ, where it is expressly provided for. Then I think you have to go into the separation of powers issue in that case, but that's something that, you know, I would be happy to litigate in a future date.
Fair enough.
For sure.
Fair enough.
I want to talk about the statute of, Judge Parker, did you have something? I'm sorry, I thought I heard you, okay. The statute of limitations problem, which is already evident, in order to not prejudice the state, I think that the court would have to enter some kind of equitable tolling rule, which would be extra statutory, which the court typically, again, does not write law. Make that up. And I want to last talk about SB 1220, which was intended to ameliorate this problem. And I would ask that the court act quickly. One thing is that this case has been ongoing since 2018. And I would like to see this court self-correct. If SB 1220 was enacted as it is right now, the legislature has made that retroactive. And so that would potentially move this case. But I think that this institution should take it very seriously to self-correct.
That goes back to my question I asked you. Really, the position here is that you're just saying, let's get rid of this previous opinion and go back and adopt the state's position from the very beginning.
Yes, the state won in the trial court, the state won in the Intermediate Court of Appeals, and those decisions were absolutely right. And
Counsel, just to be clear.
yes.
Assuming the state is correct, this comes to us on a pretrial habeas from the district court that the Court of Appeals, the Intermediate Court of Appeals, held was correct because there wasn't a jurisdictional issue because the TEC didn't have exclusive authority. So if the state is correct, our role would effectively be to acknowledge that, to say that the TEC did not have the exclusive jurisdiction, therefore there wasn't a pre-trial habeas cognizable issue, and just that would be it, correct?
That would be the end, yes.
Okay.
With that, I'll close. Thank you very much, unless there are any more questions.
Nothing. Thank you very much. Thanks to both counsel. This case and the case we heard earlier, Kitchens, will now be taken under submission. The court will stand in recess briefly for about 10 minutes. We will come back out and we'll have a question and answer period and have a couple of final comments. First of all, thank you very much for having us. Before we get into our question and answer period, there's a couple of quick things I wanted to say. First, you may have noticed we have 2 chairs empty today. We have 9 members of this court. 2 of them are very much prepared and looking forward to coming and joining us here today, but encountered family emergencies that prevented their being able to attend. They would want me to express their regrets for not being here with you today. Also, I wanted to thank very much Texas A&M International University and their hosting of this event, President Castillo, Enrique Botella, Roseanne Palacios, and Chief Perez. Also, for all the law enforcement that have been with us here this week, it's been an outstanding experience. We love Laredo, and we're very grateful for the opportunity to be here with you today. Also, the criminal justice section of the bar and Judge Navarrete at our chair, thank you very much for having us. And with that, I'll turn it over to anyone who would like to ask any questions, and I'll remind you, please, that we can't talk to you about the specifics of the case we just heard. The lawyers aren't here and don't have the opportunity to police our answers. So if you want to ask us about that, we'll not be able to answer.
Judge Newell, do you remember me from the first year of law school, UT Law School?
No, I sure don't.
Well, you and I and Clark Richards, remember that section?
Yeah.
Judge Newell and I were fresh law together at UT Law School.
Oh, yeah,
in Austin,
okay.
1994. There was 150 of us, I think. We had a governor's, Ann Richards' son, Clark Richards, was in our section.
Yeah,
Mark
sure.
White's son was in our section. And the grandson
How about,
of John...
just for the benefit of the students that are here today, how many people are in a class at the University of Texas? About 15,000, is it? That's a joke.
Meant to be.
we had 3 governor's children in our
Right.
one section.
Yeah.
Yeah,
Right, we
John,
did.
I think John Connolly's, wasn't it John Connolly's grandson
Right,
was
that's
also in
correct.
our section?
Right.
The governor who was murdered with John F. Kennedy? Isn't that right? Have I got that right, Judge? Is that right?
I think so. You know, Judge McClure was actually at UT like right after us too, so that was also pretty neat. It's a small world, so. Thank you.
That was a fun fact.
I'm just glad he didn't have other stories to tell. That's. Thank you. I appreciate your discretion.
Hi, my name is Valdemar Garcia. I'm here from Laredo, just like Judge Yuri. And so I do appellate work, but civil work. I've never had a case before, a criminal case on appeal. So my question is, when you're holding oral argument, like you were doing right now, if you have an opinion on the case from reading the briefs or your own independent research and you're leaning a certain way, how often does oral argument, what you did today, change your mind?
Well, some people have been on this court longer than others. They probably could tell you a more meaningful answer. People here immediately, just so you know, the closer they are to the middle, the more experienced they are as judges. Except for me.
I think that this pat answer I typically give on that question is more along the lines of I've seen cases lost in argument, not necessarily won. I think that a lot of times I get frustrated because when I hear questions or not, I don't think that people are necessarily answering them, and that can be frustrating. But, and I've definitely seen, I've specifically witnessed, not just from my perspective, but other advocates that get up and turn other judges off. And so that's really what I've seen. But other than that, I don't know that I've seen it sort of, I think maybe I could count on one hand the number of times I've thought someone, oh, that was such a good argument, that it really brought something that is not in the briefing and is not something that we've already considered.
I'll say 2 things on that. I agree with Judge Newell. It's a bit like depositions in a civil context. You're not going to win, but you can lose. The other thing to keep in mind is that each judge has their own particular style of coming to their decisions. Some, like me, like to chew on it for hours and hours and hours. Others who have more experience have looked at these issues before and they get there quicker. The oral argument helps me because it helps raise questions I might not have looked at, and then I go back with my staff and chew through them.
I want to add something to this, because the idea that you might lose but you can't win means that the other side and the whole idea of, so in other words, the outcome is not predetermined right before we come to this, especially I think on a court like ours. Many of the intermediate courts of appeals in Texas because they have such a big volume of cases that they're working to decide, will already have a draft opinion prepared before they come to oral argument. That is not the case at the Court of Criminal Appeals. The first time we talk about a case on discretionary review, the question is whether we should even entertain the case at all. And it doesn't really necessarily go to the merits of the answer to the question. The first time we actually get together in a room and talk about how to resolve the case is immediately after oral argument. And so the idea that those arguments are not going to influence us, I think, is a complete fallacy. Those discussions, I've been in enough of those discussions now to remember that oftentimes what we talk about when we get together is what those lawyers just told us in person, face to face. And for me, oral argument is a long-held and historic tradition of litigation of appellate cases. In the old days, the early days of this country, lawyers spent literally days coming back to court to continue to argue. They'd break for a meal, and then they'd come back to the courtroom and continue to argue. And so it's only in the more recent history that you see this limitation of 20 minutes per side. That's just a reflection of the fact that we're doing a whole lot more work than the courts used to do in the past. But I do think oral argument is an incredibly important piece of the process, and if we unfortunately abandon it because we feel overworked, then we're going to be missing something important in the mix.
Well, I think, let me add to that too. I served for quite a while on appellate court, an intermediate appellate court. For those who don't know, we have a lot of Texas. We now have 15, 3 times the next closest state. And I've practiced appellate law for, boy, almost 30 years before I came here. And to answer your question directly, how often does it change the result? Not as often as you might think, but the reason for that is that the lawyers have been in a room before. They have prepared the arguments and briefs, and we've read them, and we typically come into the argument knowing this is a case that warrants oral argument. And to me, it's where I see it as extremely beneficial. It's shaping how the opinion is going to come out, even if it doesn't change which side I'm on. And I view it as my obligation, because I'm on a public court, to give the public and the lawyers an opportunity to see where I am struggling, and I want to give you a chance. I tell you, here's the problem I see with your side of the case. Help me get where you want me to go in terms of writing this opinion. And quite often, you do get an answer that helps a lot. And it's true, I think, on every appellate court where the judges are coming in prepared. And for a long time at the U.S. Supreme Court, it was the same argument basically every time. Chief Justice Rehnquist was going to ask the first question, and it was going to tell you where he and people who thought like him thought the case was going, and here's your chance to redirect the train. And if you couldn't answer that first question, you had a problem.
Well, I think that the presiding Judge Shank actually sort of points to the idea that it's not really a fallacy to say that you could lose your case and argue, but you can't necessarily win it, because basically everything has been really developed. And so it might help you figure out where you might write the opinion. At the end of the day, you can see someone really damaging their case. And I mean, I've seen plenty of times where people come in and their opinion is not at all changed. And not just talking about me, their opinion is not changed by argument in any way.
And I'll add to that. My recent background before taking the bench was 25 years of criminal defense. And when you're arguing to a jury, and even to a limited extent, when you're arguing to a judge, passion, emotion, those can score you points. They score you almost nothing here. And to extend that, when you're in the trial court and you're arguing to the jury or the judge, you're focused on the outcome in that one case. You may be making arguments on a broader perspective of how this impacts society, but you're focused on an outcome in that case. We don't focus on an outcome in an individual case, though that's the path by which we make our rulings. We're focused on the next 500 cases, the facts of which we don't know, and what the ramifications of our rulings will be to all of the next 500 cases. Again, the facts we don't know. So it's a very different means of persuasion, because we're looking for something very different.
Thank you.
May it please the court, I did not introduce myself when I first asked the question. I apologize. I'm Stephen Todd, Assistant District Attorney for the Honorable Chilo Alanis. I have the privilege of doing Operation Lone Star criminal trespass prosecutions here in Webb County and formerly in Zapata County. So that's who I am, and I apologize for not sufficiently identifying myself.
We're familiar with your work.
We had some students that were here yesterday, but I see some new faces, some students. So would you mind telling our students, and maybe anybody who doesn't know, about the volume of cases that you see and how you make the decisions on which cases you will give the opportunity for oral argument?
Well, I guess being presiding judge, I'll try to take a whack at that. We have a huge volume. I think we are the busiest court in the country in terms of raw numbers. Somewhere between 7,000 cases a year are going to come through the court. A huge number of those are what we call writ applications. These are post-judgment. This is after the case has already been decided and someone is in prison and is seeking relief from that judgment. And we go through those cases. There's a huge volume of them. Separately, I'm guessing 1,000 or so petitions for discretionary review. As I think one of our colleagues here was saying, we don't hear court cases that we don't want to, with one exception. That is capital cases in which a death penalty has been imposed. Those cases skip the lower courts and come directly to us, and we have to hear them. And that's the only cases that by Constitution we must all sit, all 9 of us. By rule, we do that anyway. And there's different views, I'm sure, about where the court's efforts are best directed, given the volume we're looking at and the limited resources we bring to bear to deal with it. But the PDRs are very important because you're talking about cases by their definition and by the arguments that are potentially important to the entire state. A writ petition involves one person and his confinement, and still we take all of them very seriously, and our staff, we have a substantial staff, as you can imagine, that assists us with these things, are working on those. And I'm not sure what the volume is on our sister court, the civil Texas Supreme Court. It's high. They're working very hard too, but I don't think it's quite what this is. And I think if you compare it to, like, for instance, the U.S. Supreme Court, they're typically hearing about between 75 and 90 cases a year. So they do have a lot of cases are not granting, I should say that, but they're hearing cases on the merits about that rate.
Hi, my name is Valeria Palacios, and I have 2 questions, and one is for Judge Finley. So when the lawyers presented their case, you had straightforward questions and a straight, honest tone. What words of advice would you give to those that tend to get overwhelmed, especially as if someone is asking them a question right away?
I'm sorry, the last part of that was what advice would you give to?
Yes, what advice would you give to somebody who wants to go into law, become a lawyer, and to help them deal with overwhelming, cases?
All right, governing dynamics, okay? In every case, there's gonna be hundreds of different variables, different things, different factors. The real secret to being an effective lawyer, at least at the trial level, is to figure out what the individual governing dynamics for your case are. What are the 1 or 2 things that are going to be persuasive? If you're arguing to a judge in a hearing versus if you're arguing to a jury, what are the few things that are going to control? And we live in a society with a minimal attention span. And so you need to be able to boil your case down to this, this, and this. When I was doing trial work, I liked to go in and say, okay, boom, here's my story. And I had 3 prongs, bang, bang, bang. Here's my story, here's what you're gonna hear. Then I had the evidence, boom, boom, boom. And in closing, here's what you heard, here's my story, bang, bang, bang. A theme and a story. People will listen to a story. People will listen to a story with attention. And too often at trial, you see lawyers lose the attention of the jury. And you can address that by tone of voice, you can address it by projection, but the best way is to tell a story. Figure out the facts you can use, sort all the rest out, narrow it down. And when you're dealing with a panel like this, 9 judges, most of whom who have literally seen it all before, you have to narrow it down to, if we get a PDR that's got 8 issues, pretty much forget it. You have to narrow it down to one thing. What's the governing dynamic that's going to control in your case, and hammer it again and again and again. Simplify.
Good morning. My name is Natalie Flores. I'm a student here at TAMU.
You speak up, please.
Oh, okay. Good morning. My name is Natalie Flores, and my question is sort of directed to all of you judges. So how do you differentiate, like, I'd say the letter of law from your own personal beliefs or interpretations, like in a case?
Carefully.
Very carefully.
How do you differentiate the letter of the law from our own opinions? Is that right?
There is a difference?
Yeah.
That's a very subtle and important question. The U.S. Supreme Court's been struggling with this for generations. Judges, nobody comes to a job without a view, and it's easy to recognize bias in somebody else, but not in yourself. And the critical thing, I think, for all of us is to remember it's not our law. There's going to be opinions where that's why we call them opinions, not facts, where we say, here's what we think is right. And then sometimes afterwards, you say, I'm not sure we had that one as right as we would like, but you've got to be flexible enough to say, the legislature's got a role to play, the governor and the executive branch have got a role to play, and our role is a little bit different. Our role is we are the only passive actor in this system, and we're here to keep everybody else basically honest and fair and make sure that the people who are out there in the public don't need to know who we are. They can just be comfortable that there's a place you can go where people are going to be fair and the contract that's the Constitution is going to be upheld in ways that seem kind of predictable, and I'm not surprised by the outcome, and it's not somebody just giving me what they wanted to do in any particular day. It's all process. That's what we do. That's why we wear black robes, right? We're fair, we're impartial, we don't have a team, we're just calling it like we see it and bringing the best we got.
I would add, I think that the way that I try to wrestle with it on a personal level is I try to question my assumptions. I think that the thing that we all tend to forget is how often we make these assumptions and we just think that they're true because of all of our life experiences, and we just never sort of question, well, what am I bringing to the question? And what am I bringing to the issue? And is that guiding me in a way that I'm not looking impartially or fairly at the law? And there's a wonderful commencement speech that was written by David Foster Wallace called "This is Water," and it's very much about that very thing. You can go on YouTube and you can find it. But the idea is that our default setting is going to think that our opinion is the most important opinion in the history of the universe, and that's wrong. Like that, you should not indulge in thinking like, yes, whatever is happening in the universe, I am at the absolute center of it. Everything is important because it happens to the left or right of me. You have to consider the possibilities. There's other things going on, that there's things you haven't thought of that you have to sort of allow for. And that helps broaden your perspective so that you can actually try and be more fair and impartial when you're dealing with these things and get your own biases, your own assumptions out of the equation.
I think one way to do that is the fact that there are 9 of us. I'm one of the newest members on the court, and it really is valuable to me when we meet in conference because I get to hear other judges' perspectives. And I'll welcome their point of view, their personal experiences even because I find that it helps me make a better decision, and I think I'm a better judge because I serve with these 8 other judges.
I'd give you my personal perspective. Prior to going to law school, I was in the Marine Corps, and I was a basic grunt. I was given a mission, and I went and carried it out. I didn't question the mission. It wasn't my job to plan the mission. It wasn't my job to question, could we do it better this way? Maybe we could do it better that way. It's not my job to write the laws. It's not my job to say, hey, this could be written better or it could be interpreted better. I have a very simple job. Strictly interpret the literal text of the law if there's any reasonable way to do so. And I basically just stick to that. And I will tell you that in looking at the laws, at least from a judicial perspective, the skill set you have to deploy is to resist the urge to fudge it this way or reinterpret it that way, or to say, clearly this would work better in that direction. I'm not a lawmaker. I don't want to be a lawmaker. You hear it often and it's a trite. It's calling balls and strikes, and that's it.
And I want to add one more thing, because I think your question is a terribly important one, and it's one that I think every judge, especially in an appellate type of court, struggles with. And so I think from my perspective, and everybody might have a different perspective on this, but from my perspective, the easiest way to make sure that we're doing our best to keep our own passions and ideas out of the decision-making process is to, especially when a case involves the text of a statute or the text of the Constitution, to focus on the words on the page and on the meaning of those words to ordinary citizens in our society, right? Because that's what makes us all equal, right? We all live equally under those words. And the minute we start focusing on anything like, well, what's a good policy? Or even what might the legislature have been trying to do when they wrote those words, their legislative intent. That's when we open the door to the possibility of us allowing our own beliefs to infect our interpretation process. I do my best to shy away from policy, to shy away from trying to decide what the legislature might have intended, because the legislature might have intended to say that, you know, people don't have to come to a complete stop at a stop sign. They might have talked about that being their intent, but they might have written down on the page, everybody must come to a complete stop. And if that's the case, their intent doesn't matter, because the law is people have to come to a complete stop. So focusing on the words and their meaning to ordinary citizens, that's the best place to start.
We have two final questions, if you will indulge, now that we are holding you hostage here. Students are so excited. So if you allow me, two final questions.
Hello, my name is David Sosa. And I have one question. What advice will y'all give to students that want to pursue a career in law or just to be a judge?
Oh, what advice will we give to students who want to pursue a career in law? My advice is to study reading and writing and oral communication, because those are the stock and trade of every lawyer. If you can orally communicate, if you can write well, if you can read and understand the meaning of words, then you're already on your way. I mean, that's where lawyers live, in that zone.
I'm going to agree and disagree at the same time, because that's what lawyers do. I think those are three very different things, and the world continues to get more and more specialized. And these oral skills, the regular communication with regular people skills, are totally different from the writer-analyst skills. And the job of a trial lawyer is very different from the job of the lawyers that you saw here today, because in real time, they're ready for somebody like me to punch them and say, what about this, what about this? In a trial, it's totally different. You have a bunch of people in a box that can't talk back to you, and you're trying to humanize and connect with them in ways that they'll like you and they'll listen to what your side has to say. And I think to know what kind of person you are is the first thing, because there's deal lawyers and there's litigators, and they're totally different. Among litigators, trial lawyers and appellate lawyers are totally different things. I spent my career as an appellate lawyer, and when I got into a courtroom with jurors and things, I started like breaking out in sweats, like what are you supposed to do with these people? I don't understand. And trial lawyers, when they come up in front of me and argue, I can tell when I'm hearing a jury argument, and I don't like it, right? I mean, it's all soft and fluffy, and I'm ready to just start poking holes in it in a matter of seconds. So know yourself is, I think, the first thing, and then don't give up. There's gonna be people who tell you you're not very good at it, whatever. Just blow right through them. Don't let anybody get in your way.
Great. All right, one more question.
Oh, hello, my name is Ana Galvan, and my question was, what made y'all want to go from a lawyer and attorney to a judge?
Yeah, why would anybody?
Seemed like the thing to do at the time.
I can tell you from my perspective, it was selfish. I really enjoyed being a criminal defense attorney. I really enjoyed helping people at the lowest point of their life, at the darkest moment of their life, standing next to them in a courtroom, waiting for that verdict to come back, knowing that in 10 seconds, they'd either be walking out that door with their family or they'd be going to prison for the rest of their life. That really gave me a sense of being able to engage, being able to help. This role allows me to help 30 million Texans. It exponentially broadcasts that. And it goes back to something that the gentleman asked just a moment ago. What advice would you give for somebody who wants to be a lawyer or practice law? Well, the best advice I can give you is this. There's a lot of difficulty in being a lawyer. But other than this particular job, it's about the best job you can have. If you find something in it that you really, truly love, you never work a day in your life. You go in every day thinking, I'm gonna get to help that person, I'm gonna make a difference here, I'm gonna help that widow avoid foreclosure, whatever it is that really makes you feel good. Being a lawyer, and by extension being a judge, can give you that on a daily basis.
For me, it was a little simpler. I went to law school as far away from home as I possibly could because I assumed that I was going to flunk out and no one would know me after I was thrown out in the street. And to my shock, it worked out quite to the opposite, and I had these opportunities to go do interesting things like do a U.S. Supreme Court practice in Washington and work for a guy who had my seat on the federal Fifth Circuit. And from the first week I was in those chambers, I knew exactly how I wanted to end my career. I mean, just watching, the Chief Judge of the Fifth Circuit with other members of the court on important issues where you would say, my judge is probably right, but so is that other judge. How can this be, right? These are really interesting problems to have, and they're important to real people. And to me, that was very, very clear. And I can guarantee you, it's not the money. You're not going to get rich being a judge, but it's a rewarding experience if you do it right, where all you're concerned about is, this process, rule of law, and this is what holds civilization together. I mean, we have lots of countries that have constitutions and judges, but they don't function. And this one functions because we have people who are not paid terribly well, sort of committed to the idea that it's not up to them, it's up to the process that brought us all together. And to me, that was simple, just watching it happen. And I would encourage you to do that if you have the opportunity.
From Judge Navarrete.
Yeah.
You know Jim Pruitt from Rockwell?
Yes. Is that Kendra's husband?
Yeah.
Okay.
Back left.
CCA staff, make your way down to the front. You will be in our third photo. CCA staff, make your way down to the front. If you labor in the vineyard, call the Court of Criminal Appeals. Make your way down.
Who's in the first photo? Like you guys?
Just you, just y'all.